Good afternoon. The committee will come to order. On our agenda this afternoon is one bill. This is S.107, the Lumbee Fairness Act. It's introduced by our friend and colleague, Senator Thom Tillis. This bill represents the latest effort in the Lumbee Tribe's more than 120-year quest for full federal recognition. An identical companion measure passed the House of Representatives earlier this year. It's been incorporated as an amendment into the House version of the National Defense Authorization Act. President Trump has also expressed support for federal recognition of the Lumbee Tribe. In a presidential memorandum, he declared it, quote, the policy of the United States to support full federal recognition of the Lumbee Tribe of North Carolina, including granting the tribe eligibility to receive all associated federal benefits. So, once again, it's the Senate's turn to take a closer look. This committee has had a long history of examining and debating the federal recognition process for tribes, including whether recognition should occur through the administrative process at the Department of Interior's Office of Federal Acknowledgement under Part 83 or through direct congressional action. Our committee has also heard arguments that favor and oppose Lumbee going through the administrative process at Interior under Part 83 versus the congressional legislative recognition process. So today's hearing continues that work with respect to the Lumbee Tribe. I think it's important to remember that Congress has never given up its constitutional authority to decide whether a group constitutes a tribe. As recently as 2019, Congress granted full federal recognition to 4 tribes through passage of the NDAA. And since 1978, when the Interior established its administrative process, Congress has recognized at least 39 tribes. So this is serious work, and it's work that I take seriously both as a senator and as chairman of this committee. Full federal recognition establishes a government-to-government relationship between the United States and the tribe, and it also creates a fiduciary trust responsibility on the part of the federal government to the tribe and to its members. Recognition makes a tribe eligible for the special programs and services that the United States provides to Native peoples because of their status as Indians. It also affirms important elements of tribal sovereignty: the ability to govern their own affairs, to tax, to establish a tribal court system, and to exercise limited immunity from certain state and local laws. Federal recognition can also open the door to specific economic opportunities, including the ability to conduct gaming under the Indian Gaming Regulatory Act. We have a full panel of witnesses with us today, and I'm looking forward to hearing from them. However, it is notable that no representative from the administration is present. We did extend an invitation to the Department of Interior, but due to the ongoing government shutdown, the department declined to testify in person. The department has submitted written testimony, which will be made part of the hearing record and posted on the committee's website alongside the rest of our written submissions. And so with that, I'll turn to Vice Chairman Schatz for his introductory remarks.
Thank you. Thank you, Chair Murkowski, for calling today's hearing on the Lumbee Fairness Act. Congress's authority over Indian affairs is broad. It is enshrined in the Constitution, and it is plenary. One of our most sacred duties in the exercise of this authority is federal acknowledgement. We do this by either delegating our power to the executive or directly recognizing tribes by statute. Either way, federal recognition forms the basis for a tribal government-to-government relationship with the United States that is political in nature and incredibly powerful. To put this congressional power into historical context, until 1871, the United States carried out its Indian policy through treaty negotiations. Treaty making was replaced in favor of the legislative process that we use today. Over 150 years, Congress has federally recognized just 39 tribes. So it's especially poignant that since 1888, Congress has considered dozens of bills related to the Lumbee Tribe and our federal obligations to them. A majority have been on Lumbee recognition alone, including Senator Tillis's S.107, bipartisan legislation that I am a co-sponsor of. The House of Representatives has passed several Lumbee recognition bills, and the Senate has had multiple hearings over several decades. We're here today to continue to build on that record. Each time we have a hearing on federal recognition for the Lumbee Tribe, we learn more. This is a deliberative process, as it should be. Federal recognition of a government-to-government relationship between sovereigns is rare, and that's because no aspect of congressional power over Indian affairs is greater than our ability to recognize tribal relations with the United States. Thank you to our witnesses for being here today, and I look forward to your testimony and the opportunity to add to the record.
Thank you, Vice Chairman Schatz. Senator Mullin, give you the courtesy of any comments if you wish, but otherwise we'll turn to our colleague. And
Tillis is very impatient, and I don't want to get in his way. He kind of gets grumpy.
I like Senator Mullin.
We will immediately turn it over to the sponsor of the bill, Senator Tillis. Thanks for coming over to the committee. You may proceed with your remarks, and welcome.
Thank you. Chair Murkowski, Vice Chair Schatz, Senator Mullin, and distinguished members of the committee, on behalf of Senator Budd, myself, and members of the North Carolina congressional delegation, I want to thank you for the opportunity to speak in support of the Lumbee Fairness Act. This issue has come before Congress many times over the decades, but never with this level of unity and support. These days, it's rare to see Republicans and Democrats come together on anything. But when it comes to Lumbee recognition, the support is overwhelming, and it's bipartisan. We're talking about support from President Donald J. Trump, President Biden, Vice President J.D. Vance, former Vice President Kamala Harris, Governor Josh Stein, the North Carolina General Assembly, and nearly every member of our state's congressional delegation. Here in the Senate, nearly 24 members from both parties have co-sponsored the Lumbee Fairness Act, including Senator Schatz and Senator Mullin, who sit together on this very committee. And maybe most remarkable, more than 235 federally recognized tribes who have stood with the Lumbee people, including the Alaska Federation of Natives, representing 186 tribes and corporations. I also want to offer my special thanks to President Benjamin Mollett and former President Julie Kitka for their unwavering support, unsolicited and unwavering support. This kind of unity is rare. It proves that fairness for the Lumbee Tribe isn't partisan. It's simply the right thing to do. The Lumbee's history is long and well documented. They were recognized by the state of North Carolina in 1885 and began seeking federal recognition just 3 years later. That was 137 years ago. During the 20th century, the Lumbee were among the dozens of victims of the Termination Era, one of the darkest periods in federal Indian policy. In 1956, Congress passed the Lumbee Act. It acknowledged the tribe but cruelly denied them the benefits and the recognition that every other tribe receives. The federal government has since worked to correct the grave injustices of the Termination Era for nearly every single tribe, except for the Lumbee. Time and again, the Lumbee have proven their case. The records are filled with testimonies, studies, and reports that all lead to one conclusion. The Lumbee are a tribe fully deserving of federal recognition. The House has acknowledged that repeatedly, passing Lumbee recognition with broad bipartisan support in every Congress since the 116th. This year, it was unanimously included in the House-passed NDAA without a single voice of opposition. In 2022, I promised to identify and expose the small but persistent opposition to this bill. I've done that homework. What I've found is simple. A small handful of well-funded tribes hiring high-priced D.C. lobbyists to spin half-truths and stir fear, motivated by profit, not principle. At the center of that opposition is the Eastern Band of the Cherokee Indians, who I assume you'll hear from today, and their constituents of North Carolina and their lead advisor, William Pipestem. Plain and simple, their opposition is rooted in financial self-interest. And that's their right. But let's not pretend it's anything more than that. The Eastern Band has opposed nearly every recognition effort in their geographic vicinity that might affect their financial interest. They even tried to block the Catawba Tribe's land and trust application and lost, something I also supported. Now they're running the same playbook against the Lumbee. They're spending millions of dollars on lobbyists and pay-for-play reports that have been discredited and condemned by the National Congress of the American Indians. It's disappointing to see this kind of money wasted on tearing down other tribes instead of lifting up their own people. However, the lobbying has failed. The ship has already sailed, and it's headed full speed towards Lumbee recognition. Today, you'll hear the same tiring talking points, that this is somehow sets a bad precedent, that Congress should sit back and just let the Interior Department handle it. That argument doesn't hold water. Recognition through Congress is the precedent. It is the norm. Since 1978, twice as many tribes have been recognized by Congress as through the administrative process. Congress has recognized tribes by legislation many times, including the Little Shell Tribe of the Chippewa Indians and the FY22 NDAA and 6 Virginia tribes in 2017. I supported both because it was the right thing to do. Next month will mark 25 years since Congress passed legislation to grant the Shawnee Tribe full federal recognition. So, when people say Congress shouldn't act, what they really mean is Congress shouldn't act when they don't like the outcome. I invite anyone with doubts to visit Robeson County, Hope County, or Scotland County. Go to the University of North Carolina at Pembroke, founded by and for the Lumbee people. You'll see the rich Lumbee culture, their deep roots in North Carolina, and their extraordinary contributions to our state and our nation. You'll find a community defined by pride and resilience and service. Educators, first responders, healthcare professionals, small business owners, and farmers. And situated just miles from Fort Bragg, the largest military installation in the world, you'll meet countless Lumbees and veterans who have served our country honorably and for generations. They've done everything this nation has ever asked of them, and all they ask in return is fairness. I do know one leader who's visited Robeson County and has stood with the Lumbee people, and that's President Trump. Just 3 days into a second term, President Trump made it the official policy of the United States government to support full federal recognition of the Lumbee Tribe. That includes access to every federal benefit that they've earned, and now is the time for Congress to act. The Lumbee people have waited long enough. They don't ask for special treatment, only fair treatment. They've earned and deserve full federal recognition, and to my friends and colleagues on this committee, I hope you understand just how important this is. Not only to the Lumbee Tribe and the people of North Carolina, but to me personally. Madam Chair, I'm about to wrap it up. I know I'm over time, but I really need to emphasize what personal means to me. I became Speaker in 2011, and shortly after I became Speaker, I met none other than the now Chief. He was Principal Chief at the time, left and is back, Michell Hicks. He came in to tell me the story about the Cherokee and how they needed a negotiated compact, a new compact. And I told the chief at the time, I said, I need to study this, but quite honestly, I'm embarrassed to say I don't know much about your story in North Carolina. So I took time to figure out that story. And this bill and that study and the right that I wanted the wrong that I wanted to fix there was embodied in a bill that was passed by none other than me, and it's the only bill in the entire time I was Speaker of the House that I allowed to go to the floor that did not have a Republican majority vote. And thankfully, Congressman Tim Moore, who was my Rules Chair at the time, was able to shepherd this through and create a transformational result for the Eastern Band of the Cherokee. Now, 2 years later, I discovered the Lumbee Tribe, and I realized that they were working hard to maintain their culture and to do everything that they could if they were to go through the administrative process to prove that they'd done the homework, which is why I signed another bill making sure that their cultural heritage could be maintained and continue to go through the process that they were prepared to go through. But the defect in the statutes is going to prevent this from happening. The only way this happens is through federal recognition and through an act of Congress. So, Madam Chair, I appreciate your leadership, and I've appreciated your friendship in the 10 and a half years, almost 11 years that I've been here. But when I tell you it's personal to me, it's because it's an injustice that needs to be righted. I look forward to your serious consideration, and I look forward to listening to the testimony. Thank you.
Thank you, Senator Tillis, for your remarks today, as well as your continued relentless advocacy. Now we will invite the witnesses up to the table, please. We will have the Honorable John Lowery. Mr. Lowery is the chairman of the Lumbee Tribe from Pembroke, North Carolina. We have Arlinda, Locklear, who is a tribal attorney from here in Washington, D.C. We have the Honorable Michell Hicks, who is the principal chief of the Eastern Band of Cherokee Indians from Cherokee, North Carolina, as well as the Honorable Ben Barnes, who is the chief of the Shawnee Tribe from Miami, Oklahoma. So to all of you, I would just remind you that we do have your full written testimony, which it will be included as part of the official record. We would ask that you keep your comments to no more than 5 minutes so that we've got plenty of time for members to ask questions. So I introduced you going in this direction, so we will just continue it beginning with you, Mr. Lowery. Welcome to the committee, and you may proceed.
Chairwoman Murkowski, Vice Chairman Schatz, Senator Mullin, thank you for convening this hearing today and for the opportunity to speak in support of S.107, the Lumbee Fairness Act. I am John Lowery, Chairman of the Lumbee Tribe. The Lumbee Tribe has a long-standing appreciation for the vital work of the Senate Committee on Indian Affairs. Over the past 30 years, we have benefited from at least 9 hearings before this committee. Throughout the time, we have received strong support from past committee chairs such as Senators Ben Knight Horse Campbell, Daniel Inouye, Daniel Akaka, John McCain, Byron Dorgan, and many others who are true friends of Indian country. Senators, please know that your commitment to tribes and your attention to the Lumbee are deeply valued and appreciated. I am also proud to highlight the tireless efforts of North Carolina Senior Senator Thom Tillis on behalf of the Lumbee Fairness Act. Alongside Senator Ted Budd, they have championed and sponsored the cause of full federal recognition for our tribe, following the bipartisan footsteps of North Carolina Senators Terry Sanford, Elizabeth Dole, and Richard Burr. As you're aware, the House of Representatives has again taken action on our legislation. Led by Congressman David Rouser and with the support of nearly the entire North Carolina delegation, H.R. 474 was included as an amendment to the fiscal year 2026 National Defense Authorization Act. And just this morning, President Trump issued a statement supporting the advancement of full federal recognition of the great Lumbee Tribe of North Carolina. I would like to point out also that we have Catawba Nation Chief Brian Harris and Assistant Chief Patricia Leach with us today. They are our brothers and sisters directly to the west of us who we share a close bond. We also have Chief Keith Anderson of the Nesman Indian Nation of Virginia, who are our brothers and sisters to our north. They are all standing in solidarity with the Lumbee people. Behind me are members of the Lumbee Warriors Association, who are veterans of the United States Armed Forces, and we also have numerous Purple Heart recipients, including Mr. Rudy Locklear. Their service exemplifies the patriotism and love of country that defines us as a people. Senators, my roots run deep in Lumbee history. I'm a direct descendant of Henry Berry Lowery, who during the Civil War led a campaign against the Confederate Home Guard as they encroached on Lumbee land and conscripted our Indian people. Henry witnessed the murder of his father and brother, execution style, by Confederate leaders, and he vowed revenge. My great-grandfather's grandfather and members of the Lowery gang fought back against those who sought to oppress and steal from us. Additionally, I'm a descendant of Solomon Locklear Sr., one of the 44 tribal leaders who in 1888 petitioned Congress to recognize the Lumbee Tribe, an essential step towards securing federal funding for our children's education. Today, 137 years later, I stand before you once again advocating for justice and equal treatment through full federal recognition. In 1956, the United States Congress passed the Lumbee Act. Sadly, that law was enacted during the height of the federal Indian termination era, a period when the federal government was actively ending tribes' legal relationships with the United States. While the 1956 Act says that we are Lumbee Indians, and also included language stating that our tribe, the Lumbee Indians, were not eligible for full services or benefits. The language specifically says, nothing in this act shall make such Indians eligible for any services performed by the United States for Indians because of their status as Indians. And none of the statutes of the United States which affect the Indians because of their status as Indians shall be applicable to the Lumbee Indians. This problematic language of the termination era continues to hinder us today, placing the Lumbee in a legal limbo that only Congress can resolve. There is no bureaucratic process that can amend what Congress has legislated. Thankfully, since the end of termination, Congress has repeatedly taken steps to undo these unjust laws and move toward self-determination. I am confident that this year, Congress will finally amend this law, this flawed law, and extend the full services and benefits that the Lumbee deserve. A tribe's legal status should be clear, concise, and unambiguous, and the Lumbee Fairness Act ensures this for our tribe. In 1958, just 2 years after the Lumbee Act, the Ku Klux Klan attempted to intimidate our community by rallying in Lumbee territory and burning the cross. However, that night, more than 100 tribal members, many of whom were World War II veterans, stood ready, armed with rifles and shotguns, and successfully drove the Klan away. It is only by the grace of God that no lives were lost that night, and the headlines across the country bore witness to the resilience of the Lumbee Indians. Today, I stand before you as a leader of a people who have never been afraid to fight, to stand our ground, and to resist oppression. When we are pushed, we push back. As a descendant of Henry Berry, Solomon, and the brave Lumbee who faced down the KKK, I urge you all to act now to do everything within your power to pass the Lumbee Fairness Act and eliminate the harmful termination-era language. Henry, Solomon, my grandparents, my father, and many others are no longer with us. Senators Sanford, Inouye, Akaka, McCain have all passed on. Senator Doe was in her twilight years. Do not let us bury another Lumbee or lose another ally in this fight for justice. Congress must move to ensure the Lumbee Indians are no longer second-class natives in our own land. Thank you. And Chair, I would like to submit to record a comprehensive list of resolutions and letters from federally recognized tribes and tribal entities that support Lumbee recognition. List includes Catawba, Tunica Biloxi, Oneida Nation of Wisconsin, Pascagoula, Mashantucket Pequots, and many more. Thank you.
We'll include that as part of the record. Thank you, Chairman Lowery. Ms. Locklear, welcome.
We'll try again. Thank you very much. We appreciate the opportunity to speak again today. My name is Arlinda Locklear. I have been an attorney working with the tribe on this effort since 1988. So I've been at it for a few of those times that the chairman has referred to, as well as other witnesses today. We have had multiple hearings and multiple opportunities to act and to give justice to the Lumbee people since 1899, when the first federal legislation was introduced. All of those bills have failed. And let me tell you, that has been a heartbreaking process for the Lumbee people. But we owe a vote of thanks to this committee in particular, because as a result of that process, you have developed the richest record that exists for any non-federally recognized tribe in this country. We have a record that allows you to proceed with the enactment of the S.107 with full confidence that by doing so, you would extend full federal recognition to a tribe that truly exists as such. The most important document that's in that long, rich record is a report that was asked for, sought by this committee, and submitted in 1915 by Special Indian Agent O.M. McPherson. We have particularly his record, which I have with me today, as well as the testimony of multiple expert witnesses over the last 100 years that give you the body of evidence to prove tribal existence. I think it's worth noting the quality of the experts and the preeminence of their appearance here and the testimony that they provided in support of federal recognition. We are honored to include among that group Dr. Jack Campisi, who has probably authored more petitions in the administrative process than any other expert. We include also Dr. Sturdivant, who was the general editor for the authoritative Smithsonian Handbook of North American Indians. We include among that group Dr. Ray Fogelson, who is no longer with us, but Dr. Fogelson was the editor for the Southeast volume in particular of the Smithsonian Handbook of North American Indians. And we count among those experts Vine Deloria, who spoke eloquently in 1988 to this committee, in particular about political authority. What I would like to do this afternoon is summarize very briefly what the characteristics of tribal existence are and give you confidence in the record that you have already that establishes those criteria. In a Supreme Court decision in 1901 called Montoya versus the United States, the Supreme Court gave us guidance as to what an Indian tribe is. The Supreme Court indicated that an Indian tribe consists of a body of Indians of the same race, factor number one, who are united in a community in a particular territory, factor number two, and who are united under one leadership or government, factor number three. A few years later, in 1913, the Supreme Court spoke in United States versus Sandoval. And in that opinion, the court went to great lengths to confirm this body's pre-ultimate authority to make the decision on establishing a formal government-to-government relationship with an Indian tribe. It noted that that authority is limited only to those groups that are, quote, distinctly Indian communities. So we have some indication of what those criteria are. I would like to speak very briefly to those with regard to Lumbee. First, a body of Indians. Your record, beginning with the 1915 McPherson Report and continuing to today, establishes that there is a single related body of Indians residing in Robeson and adjoining counties who call themselves Lumbee, and I will note for the record, have done so informally even before the adoption of formal state recognition since the early 1920s. That has been the name we have chosen for ourselves. Second, these folks are united in a community occupying a particular territory. They are so united in a community that even today, more than 60% of modern-day enrolled members are married to other Lumbees. They attend all Lumbee schools, they attend all Lumbee churches, and their primary interaction is among other Lumbees. They also occupy a territory that they've been in since the time of first sustained white contact in the early 1700s, and that's Robeson and adjoining county. That's home. And the record establishes, your record, that more than 50% of the enrolled members of the tribe reside today in that traditional territory. Finally, leadership. Many of the events that the chairman spoke about demonstrate the effectiveness and the repeated assertion of independence that the long record of political authority shows among the Lumbee people. And in this regard, let me highlight the testimony that you received in 1988 from Vine Deloria, who spoke eloquently about the form of leadership at Lumbee. He noted that more than any other federally recognized tribe, the form of leadership at Lumbee is more like the traditional form of leadership that existed before the adoption of the IRA and before the formation of formal tribal governments. That is what leadership among indigenous communities looks like, and it still exists at Lumbee today. Finally, let me say a word about, very quickly, the administrative process. These facts and criteria and evidence that I have summarized for you indicate that under those criteria, we have established what they refer to as high evidence of tribal existence. The concentration of membership within a defined territory, Robeson and adjoining counties, and the high in-marriage rate themselves, those two factors are considered to be conclusive evidence of tribal existence in those regulations. So you have the evidence before you. We urge you to act, and we think you can do so, again, with full confidence that you are recognizing a true Indian community. Thank you.
Thank you, Ms. Locklear. Next turn to Chief Hicks. Welcome.
Shionagad, Dioloshki Dogwado, Chair Murkowski, Vice Chairman Schatz, and members of the committee. Thank you.
Can you move your microphone closer to you?
Thank you on behalf of the Eastern Band of the Cherokee Indians. I want to express my deep appreciation for convening this substantive hearing and for your willingness to examine the facts. A careful evidence-based review of this matter is long overdue. Your commitment to that standard honors every federally recognized tribe and the integrity of this committee's work. I speak today not to question anyone's personal identity or heritage. This is not about policing identity. It is about evidence. It's about documentation and the integrity of federal recognition process. I stand here as Principal Chief and as the voice of generations of Cherokees who safeguarded our identity, safeguarded our language and our sovereignty through centuries of forced removal, division, boarding schools, and unprecedented political pressure. This bill asks Congress to recognize a group that has never demonstrated descent from any historical tribe. Let me be clear. For more than a century, this group has cycled through claimed identities, the Croatan, Tuscarora, Siouan, Cheraw, and even the Cherokees, choosing whatever labels seemed most advantageous at the time. Yet in all this time, not one verifiable genealogy, historical roll, treaty, or historical document has demonstrated continuous tribal existence or descent from a historical tribe. Their claims rest on theories, speculation, and invented narratives. Federal records show this clearly. In the late 1800s, only 223 individuals in their counties identified as Indian. 10 years later, the number jumps to 4,000. 1,700% spike. What changed was not ancestry or history. It was access to a separate school system for those willing to claim Indian identity on paper. But the deeper historical record is even more revealing. For generations before that moment, the families this group now claims as ancestors appears in official records as free British subjects and later American citizens, not as Indians, not as a tribe, not as a political community, distinct from others. They exercised their full civil rights. They did not claim an Indian identity. Only after the Civil War, when North Carolina rewrote its constitution and imposed new racial restrictions on non-white citizens, did these families suddenly adopt an Indian identity, calling themselves Croatan, to access a separate Indian school and government resources. And history that was not the end of identity shifts. For over 40 years, from 1913 to 1953, this group identified as Cherokees and legally recognized by North Carolina as the Cherokee Indians of Robeson County. Over the objections of the Cherokee Nation and the Eastern Band of the Cherokee, their members self-identified as Cherokee on federal school applications, and they petitioned Congress for recognition as Cherokee. Some individuals still assert Cherokee identity today. When those claims were rejected because they could not be substantiated, the group adopted yet another identity. This is not a pattern of continuous tribal existence. It is a pattern of shifting assertions driven by circumstance, not historical evidence. If Congress passes this bill, this group would be the first American in history to receive federal recognition without demonstrating any descent from a historical tribe. This is not fairness, it is abandonment of every safeguard that protects tribal sovereignty and identity. The Office of Federal Acknowledgement exists to ensure recognition. Decisions rely on proof, not assertion, documentation, not desire, historical truth, not political pressure. Recognition confirms a documented tribal reality. It does not create one. Congress has also been misled on the cost. Independent analysis shows the real price is in the billions. Diverting treaty-based resources away from tribes with proven history and legal rights. I want to state this plainly and respectfully. There's no tribal language. There's no treaty relationships. No continuous tribal government. No documented lineage to a historical tribe. We do not fear another tribe. I want to make that clear. We fear falsehood becoming federal law. If there is evidence, let it be presented. If there is a tribal origin, let the OFA confirm it. And if they meet the same standard every other tribe meets, we will welcome them to the group of federally recognized tribes. But Congress must legislate identity by replacing evidence with assertion. In conclusion, thank you in advance for insisting that proof matters and that federal recognition must remain grounded in the truth. On behalf of the Eastern Band of the Cherokee Indians, I urge you to hold the line, even though it's difficult. Protect the integrity of tribal sovereignty. Protect the integrity of federal recognition. Protect the principle that history and evidence still matter in the United States Congress. Shki, Data Dago Hunyu, Hawa.
Chief Hicks, thank you. Thank you very much. Chief Barnes, welcome.
Howenoki, Howese Peconia, Ben Barnes Nitesito, Okimasa Wanoki, Keto Yokupi. Senate Committee on Indian Affairs, Madam Chair, Murkowski, Vice Chairman Schatz, Senator Mullin, other senators of the committee. Niaweh for inviting me. My name is Ben Barnes, Chief of the Shawnee Tribe and Chair of the United Indian Nations of Oklahoma, serving the 38 federally recognized tribal nations in Oklahoma. I also serve as the Chair of the National Native American Boarding School Healing Coalition. Let me begin with the truth that elders teach us. Sovereignty is the inheritance of survival, not the reward for claiming it. Our nations exist because our ancestors endured forced removal, warfare, termination policies, and the boarding school system. Federal recognition does not make a tribe. It acknowledges a people who never ceased to exist. When the United States forced my people from Ohio through Kentucky and Missouri to Kansas and finally to Oklahoma, we did not reinvent ourselves at each river we came to. We remained Shawnee. We carried our ceremonies in secret. We kept our language alive in whispers. Our government lived in the hearts of our people, even when the United States wished it would just vanish. Nationhood is not a label to be chosen, but an identity carried through generations of removal, loss, and resistance. I have seen what happens when identity becomes something someone can simply declare. Across every homeland we were forced through, Ohio, Missouri, Kentucky, Kansas, there are now groups calling themselves Shawnee who do not speak our language. They hold no Shawnee ceremonies. They appear nowhere in historical record or records or rolls. And they have no documented Shawnee ancestors or ties to our community. The first time that one of these groups opened a bank account using the name Shawnee, I learned a hard lesson. If identity becomes self-assertion instead of a documented history, sovereignty becomes a sandcastle waiting for the tide. That is why we are here, to defend the sovereignty paid for in blood, land, and with children. Now in turning to the matter before this committee. For years, this group has moved from identity to identity, lost colony, Croatan, Cherokee, Chiraw, Siouan, Lumbee, changing claims but never producing documentation to support any of them. And so, the United Indian Nations of Oklahoma turned to a respected historian and genealogist to examine the record. That research did not attempt to define who the Lumbee are. It simply asked a single question. Can the Lumbee's tribal claims be verified by historical and genealogical evidence? The resounding answer was no. The expert found no demonstrated descent from a historical tribal nation, no continuous tribal government before the mid-20th century, no ancestral indigenous language community, and census records showing that ancestors identified as free persons under British and American law, but never as a tribal polity. These findings do not come from emotion or politics. They come from archives, from documents, and history. Now I must speak from a sacred place, a place where grief and memory live in our communities. As chair of the National Native American Boarding School Healing Coalition, I have carried the names of Native children who never came home. I have walked the ground where they lie without markers. I have sat with survivors who still flinch when they hear their native languages because it only brought punishment. The Lumbee have invoked boarding school history to claim indigeneity, but the record tells another story. 9 individuals now held up in Lumbee narratives attempted to enroll at the Carlisle Indian Industrial School. Carlisle rejected them because they did not meet the federal definition of Indian. They were only admitted after claiming, falsely, to be Cherokee. An independent genealogical review shows not one of the 9 had Native ancestry. Yet their descendants now identify as Lumbee, and Lumbee leadership presents that episode as proof of tribal status. That is not survivorship. That is borrowing our pain to manufacture a political identity. Our children's trauma is not a credential. Our unmarked graves are not a strategy. Our ancestors' suffering is not a political accessory. To allow trauma to be impersonated is to betray the memory of the children and to denigrate oneself. There is a path established to federal recognition, the Office of Federal Acknowledgement. It exists to examine the history, continuity, and nationhood. It is open to the Lumbee, but they have been told that they may use it. They refuse. The truth is simple. People confident in their history do not avoid the place where history is examined. So I close with where I began, with sovereignty. Tribal nations predate the United States. Federal recognition does not create us, it acknowledges us. If Congress replaces documented history with political momentum, if identity becomes a matter of assertion rather than continuity, then this body will not be recognizing tribes, it will be manufacturing them. And once that begins, sovereignty will not be defined by history, but by votes. Niwen, Nukuchchaye, Hinileki, I welcome your questions.
Chief, thank you very much, and thank each of you for your testimony here today and for the opportunity to now engage in a round of questions. I'm going to defer my questions to Senator Markwayne Mullin from Oklahoma. You may begin.
Thank you so much. Chief Barnes, how was the Shawnee tribe recognized?
We had a separation from the Cherokee Nation in the year 2000. It was we were under the authority of Cherokee Nation as citizens, and that was via
how was you recognized? Which path did you choose for recognition?
We had a path of recognition to separate us from the Cherokee Nation, and that was established by an act of Congress.
Act of Congress. How many paths of recognition is there for a tribe to go through?
You have the act of Congress. You have an OFA process.
And you chose to go through Congress because?
We had an OFA review. It came down to a document that was signed by Fred Half Moon in the 60s. And if our continuity of government, it hinged upon that government had been continuous. So as part of our separation, our separation was not identifying us as a tribe. It was separating our tribe from the Cherokee Nation. We were late to the Oklahoma.
But you asked for recognition through Congress, right?
That was how our process happened. Yes, sir.
Do you believe the Lumbees are native?
It's not what I believe, sir. I have no belief in the matter. My matter is in the OFA. I believe in the process. I believe that the OFA process exists whenever
But isn't there two ways?
Evidence.
Isn't there two ways to be recognized, right? Congress has authority to recognize, correct?
I agree, yes.
Okay. Chief Hicks, do you believe the Lumbees are native?
I think there is potentially native descent. It doesn't make them a tribe.
Why did North Carolina recognize them then in 1885?
North Carolina, to my understanding, has different standards for the recognition. I'm not sure today that the Lumbee could pass the standards that have been put in place by the state of North Carolina.
Did the federal government recognize them in 1956?
To my understanding, and my conclusion of the 1956 acts is simply recognize the name of those who self-proclaimed Indian in a 5-county area in eastern North Carolina.
Did the federal government recognize them as a tribe in 1956? That was my
I believe
question.
so.
Okay.
Not in my conclusion.
So, do you believe there's 2 paths for recognition, and Congress has a right to have to recognize them?
I do agree with that. Yes. Congress
Now,
is
you
one of
raised
the-
up concerns that it was the cost.
Mm-hmm.
Is that correct?
Yeah, that was part of my testimony.
So, if it's the cost, should the federal government not recognize any more tribes coming in?
That wasn't the point of the cost. I think it needs to be
Well, it
considered.
is, because when you're raising cost, you're raising the cost that it would be to recognize the Lumbee Tribe. Because I do believe they're native. I've been accused of not being native, and I always laugh, and I said, I can't control who my ancestors loved, but I still live on the same allotment land where my family stopped walking, because I am Cherokee, and I'm proud to be Cherokee, and my family's been there since 1840, but yet I've been accused because I may not look full native. And I have a problem when someone starts saying that. I have to actually take it a little personal. And Chief, there's actually a split between Cherokee Nation and the Eastern Band. Would you agree?
What is your question?
There was a split between Cherokee Nation and the Eastern Band. Cherokee Nation, my ancestors, we walked, and the Eastern Band stayed back. Correct?
That is correct.
But you were fairly recognized. Shouldn't you be recognized underneath Cherokee Nation at that point?
I mean, if you look
Because
at,
we're all descendants, Cherokee Nation.
do I get to respond?
Sure.
So if you look at, the history of recognition, obviously the OFA was not established till 1978. The government, stopped doing treaties in 1871. The Cherokees, without question, was an established government. And, if you look at,
I know the history of the recognition. I get that. My point is that you're saying that the Lumbees, that they are or aren't descendants of the Eastern Band or Cherokee Nation, really, because Cherokee is Cherokee, so it'd be your descendants of Cherokee Nation, in my opinion. But you're saying that they should be recognized because there should be part of you, but you should be part of Cherokee Nation. It doesn't make any sense to me, because you're complaining about cost, you're complaining about their path of recognition, and you're complaining that they may or may not be native because they don't have the heritage behind it. And I'm saying, well, they were recognized in 1885. The cost shouldn't matter, because if that's the cost, then we shouldn't allow any more tribes to come in, and we should stop enrollment, because we have a federal obligation as Congress, a treaty obligation, a constitutional obligation to have oversight of the tribes. We have the authority to be able to recognize tribes, without question. And it just seems like this argument continues to go through because of my opinion of the territory dispute. That's my opinion. Because you can't look over there and say they're not native. I mean, turn around and look, and you're telling me they're not native?
I've seen the crowd.
Okay, and you're saying that that's not native faces?
That's not for me to determine. That's for the OFA
But we
process.
are determining it.
That's for
And
the
that's why I
OFA
support recognizing them. Because my fight up here has been always for Native Americans. I was shocked when I got up here that when I first got to Congress, it was just Thom and I were the only natives in Congress at the time. And I'm in the Senate, and I'm the only Native American in the Senate now. And I hate when we fight among ourselves, because we should all be in the same boat, rowing the same direction. If we're Native, then we were wronged a long time ago by the United States. And we've been fighting for recognition for a long time. And when we have in-house fighting, it causes Congress sometimes to have an impasse. And I think you know that. This happens all the time. A lot of times it has to do with gaming. And all we're saying is the Lumbees have a right to be recognized just like you have the right to be recognized.
And we don't disagree with that, as long as it's through the OFA process.
But if they have two options, why is it your opinion that they can't choose the one to go through Congress?
Because that's why this department is established. It's for evidence and
But there's clearly two paths.
substantiation.
And I appreciate the paths they took. Chair, thank you for the extra time. Thank you for allowing me to go first. For the record, that's already been established by the Interior, they do support this process, and they support the Lumbees of becoming recognized, and I, too, also support the Lumbees of being recognized.
Thank you, Senator Mullin. Senator Schatz.
Thank you, Chair, and thank you to the testifiers. Just a couple of thoughts before I ask Professor Locklear a couple of questions. You know, I think it's really important to assume good faith here, and what I've heard is a kind of concerning series of accusations about bad faith. And I'm trying to go back to 1888 and imagine that the Lumbee people, whatever they were calling themselves, whatever language they were using at the time, says, you know what, why don't we pretend we're a tribe and petition the federal government? If this is a conspiracy, it is long-standing, kind of odd, counterintuitive conspiracy. The more likely explanation is what the Department of Interior said about 90 years ago, 100 years ago, when they explicitly said, we're not going to recognize this tribe because the census is too large, because we can't afford to absorb the cost of delivering services. And I think that is, by the way, I think that's a valid concern for congressional appropriators, right? If we are to recognize Lumbee, the rolls just increased. The total number of people in Indian country went up, which means IHS, BIE, BIA, and all of those services are going to have to increase by the percentage that the rolls increase. And so that's a real issue. It's just not a reason not to grant recognition. And the reason I'm animated about this is that I don't know whether Native Hawaiians are ever going to come back to this Congress and seek recognition. But I remember, I was not here, but I remember when Danny Akaka, chairman of this committee, tried to get recognition. And the arguments were, do you know how many people that is? Do you know how much that's going to cost? And then, well, they're not Indians. And so I don't take it as personally as Senator Mullin, but I do take it personally. And I'll just say one other thing. You can go through the administrative process or you can not. But the Constitution vests not just the Congress, but this committee with this authority. So it may be that you think we should have gone, or these folks should have gone through the administrative process, fair enough. But that is not a meaningful obstacle to consideration of Lumbee recognition. So, Professor Locklear, I just want to give you an opportunity to, again, respectfully, rebut some of the claims made by the opponents of this legislation. Three things. Lumbee has used different names for themselves, that they have no language, and that they do not descend from a historic tribe. Could you address those three assertions?
With pleasure, Senator, and thank you for the question. First of all, with regard to the name and why it came about, the Lumbee children in 1884 were not able to go to school. Our children could not read or write. We were not allowed to attend either white or African American schools. In 1885, our leaders sought recognition from the state of North Carolina for the purpose of establishing schools for our children. We prevailed with the assistance of a Mr. McMillan in the House, who deemed himself to be an amateur historian at the time. Mr. McMillan chose the name Croatan for our people. But in his legislation, he did important things. He established a government-to-government relationship. He allowed the creation of an independent school system run by the tribe, limited to tribal children, and taught by members of the tribe. To my knowledge, no other tribe in the United States can claim that history. So beginning in 1885, we controlled our own school system until the 1970s, when a federal district court ruled that the state of North Carolina must desegregate its school system. We thought we were exempt from that because, after all, we are an Indian tribe. But the judge told our parents, You must bus your children because this is a racial classification because you are not federally recognized.
Okay, and to the language?
Yes. There is no requirement in either Supreme Court or other federal court authority or the acknowledgement regulations that our opponents so warmly embrace that require the presence of a language.
Yeah, I mean, a lot of these things, it seems to me, are historical facts, and they happened because of United States federal government policy. We lost language because of federal policy. People lost a land base because United States federal government policy. And then it is not surprising that the Department of Interior repeatedly rejected the claims of the Lumbee people, because the Department of Interior, I mean, the idea that we should accept the precedent of the Department of Interior from generations back, when I think there is unanimous bipartisan agreement that the whole purpose of this committee is to reverse all of those policies, termination and assimilation. And to use that as a proof point against recognition, I find to be not compelling. Now, there are criteria that we're to use to determine whether or not to recognize Lumbee. But the idea that, well, DOI didn't do it in 1930, or they don't have their own language, well, there are, and frankly, we work a fair amount on language revitalization, and there are a lot of tribes that have very few native speakers left or none. And so none of this is disqualifying because, frankly, many, many native people across the country have experienced that. I did not expect to get so exercised, but I appreciate your testimony.
If I may I offer
with
one
the chair's
final,
permission.
Go ahead. Go ahead.
Thank you. One final fact on the language point that I think is important. Vine Deloria, when he testified in 1988, made note of the fact that he had not only personal knowledge of the Lumbee tribe, but also family knowledge of the Lumbee tribe, because his aunt, Deloria, had gone down to the community, who was a noted linguist, for the purpose of studying the remnants that remained of tribal languages. And she made note in 1940 that those remnants existed, and her purpose was to establish a dictionary. She did not complete that work because she was not able to get funding. They were not interested in our community to do so.
Thank you, Vice Chairman. Chief Hicks, I want to direct this to you because you have made very clear that on behalf of the Eastern Band, that you think that the Lumbee should go through the Office of Federal Acknowledgement, through the administrative process, rather than come through recognition through Congress. Maybe it is accurate that the administrative route is perhaps more costly, harder to do, subjective. Maybe we need to look at that in terms of whether greater oversight is needed there. But as Senator Mullin has indicated, there are two tracks, two routes that you can proceed for recognition. I almost find it curious that federal recognition is ultimately about a political relationship between a sovereign tribe and a federal government. So it just seems somewhat curious that we actually set up a process where that decision can be delegated entirely to an administrative state. But I'm not going to ask you to resolve that question for me. What I want to turn to is your written testimony. You claim that the Lumbee situation is uniquely beyond Congress's capacity to understand and evaluate. Can you explain why you feel it is unique in some way, separate from other tribes that have gained recognition through Congress? Because again, we have this process. It has been repeatedly exercised in terms of its constitutional authority to gain tribes. So if you can cite to what you feel are some of the unique aspects as to why Congress should not be the avenue here?
Thank you, Chair Lady, for that question. I think, if you look at the gaps that have been clearly identified by historians, by researchers, related to the history, these are aspects that I feel need expertise. They need genealogists. They need historians that do this on a daily basis. And, unfortunately, congressional staff don't always have that expertise to really dig into, the subject matter documents or the church records or, court records, things of that nature to really relate back to what is necessary as we feel to prove what you're saying is substantiation. And so, again, I think as you look at, that setup and that structure, OFA is better suited to make these determinations.
How do you respond then to Ms. Locklear's statement that she made early on that given the number of congressional hearings here in the Senate, in the House, that this issue of federal recognition that Lumbee is seeking has not established quite a voluminous congressional record with which to be able to turn to?
I truly believe that, if the Lumbee group would go through the OFA process, they would get the answer that they're looking for, wherever that answer falls. And, as you think about, this issue is well over a century old, and it continues to come back to the same conclusion. There's too many gaps in the genealogies. There's too many gaps in the history. There's no treaty relationships. Lumbee does not have a sister tribe in Oklahoma. There's so many things here that need to be evaluated. That's the importance of why it needs to go through the OFA process.
So, Ms. Locklear, let me turn to you. You have testified that congressional recognition is needed to correct what you have termed an injustice. Beyond that, you've got some practical differences between recognition through Congress and recognition from the federal acknowledgement process. You've got the ability to take land into trust, particularly in the post-Carcieri world here. Can you speak to some of these practical differences between the legislative and administrative recognition and whether you think those are drivers for this legislation?
Absolutely, they are. Let me summarize with just a few points. First of all, I think it's important to put this controversy in some general history. As the Special Indian Agent reported in 1915 in the O.M. McPherson report, there is a history of 300 years of hostility between the Cherokees to the west and the ancestors of the Lumbee people, including the Shira, the Hatteras, and related Siouan-speaking people. And we just have, I think it's important to understand that context. As to the other issues, so as a practical matter, because of that, only Congress can resolve it forever. We have been at this for more than 100 years now, and I guarantee you that were the tribe to go through the acknowledgement process and succeed, as I am confident we would, there would be a lawsuit filed by the Eastern Band of Cherokee to try to set that administrative agency decision aside. That would not resolve it. There's only one way to finally resolve it, and that's through a conclusive act of Congress that extends full benefits and services. As you also implied, there is a problem with the Carcieri issue, which relates to eligibility of newly recognized tribes to receive land in a trust and thereby be treated like all other federally recognized tribes. Because of that 2009 Supreme Court decision that we call Carcieri, the only way to resolve the eligibility of the Lumbee for that process is through an act of Congress. Only Congress can clearly indicate that it considers the 1934 date to be insignificant and whatever may arise out of the Carcieri decision, notwithstanding those terms, the tribe is nonetheless eligible for the land in the trust process. And finally, if there is going to be a special addressing of the of the cost factor. We don't think it's necessary, which I'm happy to expand on, but only Congress can do that as well. Congress is the one who appropriates the money, and if there needs to be more money for the Lumbee services, Congress can do that. We think the existing processes for appropriations will protect the presently recognized tribes, both in BIA and IHS processes, provide that only through the appropriation of additional funding that pay for those services will the Lumbee members receive those services at the end of the day. So federally recognized tribes now are protected. That being the case, if they believe there should be an increase in federal funding for the IHS and the BIA, again, that's a political decision to be made by the Congress. So we think for all of those factors, one final one, if I may. Only one other time in history has the Congress put an Indian tribe in the same position that it put the Lumbee tribe in 1956. And that was with the Isleta del Sur Pueblo of Texas. Congress passed a statute in 1968 for that tribe, which was at the time federally recognized, which basically said, we transfer any responsibility we have for this tribe to the state of Texas, and we're going to impose termination language upon the tribe. And in the legislative history on that act in the Senate, it specifically says that 1968 act, which then referred to the natives as Tiwas of Texas, was modeled upon the 1956 Lumbee Act, the only other time Congress has done that. And Congress fixed that problem in 1987 by passing legislation to recognize fully the Isleta del Sur Pueblo of Texas. Now, if Congress does the same for us, there are no other tribes in that position, and that's what makes it fair and just, as well as the only appropriate and fully dispositive way to finally and conclusively resolve these issues.
Senator Cortez Masto.
Thank you. I appreciate the comments for everyone and the uniqueness of the hearing today. Ms. Locklear, let me ask you this. There's two ways to get this recognition. We've talked about that. One is through Congress. You've talked about that.
Yes.
And then the other is through the DOI and the Office of Federal Acknowledgement. Am I hearing today that we should eliminate the Office of Federal Acknowledgement and just rely on Congress to do this in the future?
Not at all. Not at all.
So what do you have any concerns with the Office of Federal Acknowledgement and how the process plays out?
Historically, we have, and we have expressed those along with other non-federally recognized tribes in various
But I'm
forms.
saying now, right now, not historically, now.
It is
because I'm
greatly
here now,
improved.
and we need to address this. Are there any concerns that you have with the office right now?
It has greatly improved as a result of the changed regulations in 2015.
Okay, so can I just say, Chairman Lowery, what's to stop you? It sounds like you have the support of the administration, you have the support of DOI. What's to stop you from going through that process now and getting what you're seeking, but go through an evidence-based process to address some of the concerns that we've heard from the other tribes?
Yes, ma'am. Although there has been changes to the BIA process, we still do not know if it's going to take 20 to 30 years, just like it already does. And I don't want my people waiting another 30 years to go through the process. And then once there has been a rendering done by BIA, there will be opponents who can then bring forth a lawsuit. And I have no doubt that Eastern Band Cherokee 30 years from now will bring forth a lawsuit that will take us into another 10 to 20 years. And then 50 years from now, my grandson will be sitting here doing the same thing.
So the concern is that there would be a lawsuit to any decision that was made by
Absolutely. And the concern is how many decades is it going to take? So I think Congress really needs to take a look at the BIA process. I don't know any other government program that takes 20 to 30 years to come to a conclusion.
Ms. Locklear, let me ask you, because does the process, is that part of the problem? Do we need to look at the OFA and say this process is taking 30 years? It's too long?
Frankly,
do we need to address this in Congress?
That may be the case, Senator.
Is that true?
At this point, we don't have enough experience with how the new regulations will be administered to give a full answer to that question.
So there's new regulations now that the tribe has not gone through, so you don't know how long it would take. Is that right?
That's correct.
Okay. So let me ask you, both Chief Hicks and Chief Barnes, you talked about this. Let me just say, I understand the two ways to do this. One's through Congress, but you got to get the votes of the members of Congress. No guarantee you're going to get that. But there's also an evidence-based approach. I'm not in a position to look out in the audience and, like some of my colleagues, to say who is a member and who isn't. Just like I'm not in a position, and I don't think I should be looking out in my community saying just because you have brown skin, you're undocumented. Yeah. So there has to be an evidence-based approach. And that's why it was created in Congress. But if it's not working, I would want to know, because that's not fair. But we need to hear that conversation. And so let me ask both Chief Barnes as well as Chief Hicks. Talk to me about this evidence-based approach and why it is so important that the administration have a process like this.
If I may, Senator, and thank you for that question, I'll give an example of one that did take a considerably shorter time, was Little Shell Tribe, where Little Shell was denied at OFA, and then they went through a congressional process. Indian country decried that and said, no, you got this one wrong. The Chippewas came together and says, no, we've got this one, you got this one wrong. This one is a tribal nation. And historically, because of a technicality on Little Shell is a tribal nation. So that is one of those instances where the OFA process, even though it's flawed, and I don't know of any federal institution that's perfect at this time, even though the OFA is not perfect, it still yielded some results on behalf of Little Shell, which ultimately did tribal nations come together and say, on their behalf, look at the evidence, and this technicality should not keep Little Shell from being a tribe. All we ask is they follow the same path as Little Shell, go through the OFA process.
Okay. Chief Hicks, anything else to add to the
just, I do feel, as I responded earlier, is that, the OFA is, it's without question uniquely equipped to critically evaluate, all the related criteria. And there's several criteria that come into play, based on the claims. And, having skilled, highly skilled and professional, experienced folks to be able to do that, I think is critical. But I do want to just respond to the other question around the OFA process. We have openly supported the expedited approach, for this group to go through this process in more than one scenario. And we still feel that there is an opportunity to not extend this 20 or 30 years, that it's something well short of that, to do this evaluation properly and to get the answer that is being sought in a timely manner. And again, publicly, we support that, and we think that it is a good decision point.
So you would support, if they were to go through that process, you would work with them to say this needs to be expedited by the administration, we want something in a timely fashion?
Without question.
And would, let me stop there. I know my time is up. Madam Chairwoman, thank you.
Thank you, Senator. I just have a couple more questions here this afternoon. And I'll probably direct this to you, Chairman Lowery. It's pretty clear that a tribe's authority to basically determine to define its membership is really central to its existence as an independent political community. The legislation that Senator Tillis has introduced directs the Secretary of Interior to verify the Lumbee Tribe's role for service delivery purposes. Mm-hmm. The verification is limited to confirming documentary proof that members meet the criteria established in the tribe's constitution that was adopted November of 2001. So a couple questions for you this afternoon. Right now, as it stands, what is required for enrollment in the Lumbee Tribe?
Yes, ma'am. Thank you for the question, Senator. So we have a base roll. We have a couple base rolls. One is the 1900 census and one is the 1910 census. And the reason those are our base rolls is because that's the first time that the federal government in the standard census process actually identified American Indians. And so you have to be able to trace your lineage directly back to the 1900 or 1910 census. So if you do not have a ancestor that was documented by a federal census as an American Indian, you cannot be a member of our tribe. Also, you have to maintain contact. So we're very big on, if you do not live home, you have to come back home. You have to come back to the homelands. And
So what does that mean when you say maintain contact?
Yes.
Come back for like an annual meeting, or what specifically?
Well, we have it where you have to come back every 7 to 8 years.
Okay.
So you have to come back, you have to visit, you have to maintain a relationship with your people. So you cannot become, you cannot go and get your citizenship and then leave out and never come back home. So we require our citizens to come back and to maintain contact with their tribal community.
And at this moment, how many do you currently have enrolled?
We have just over 60,000 enrolled citizens of the Lumbee Tribe, North Carolina.
Okay. And then the source documents for enrollment are the two that you have just described. You have to
Yes,
be able
ma'am.
to trace back to just those two.
Yes, ma'am.
Okay. And then this one is probably directed to you, Ms. Locklear. There's been a fair amount of discussion today about the various names over the course of a century. And it wasn't until later that the Lumbee officially adopted their name. Because the point has been kind of disputed by witnesses today and made a little bit of an issue, can you state for the committee record today which historical tribe or tribes the Lumbee Tribe descends from?
I can, and I can do so based on the record that's been developed by this committee. There are two principal sources for that. The O.M. McPherson report from 1915, which identifies the ancestry of the tribe as the coastal North Carolina tribes, Siouan-speaking, related tribes, including the Sherall, the Hatteras, and others. In addition, you had the testimony of John Swanton, a preeminent anthropologist in the field, in 1934, who testified that in his view, the tribe descended principally from the Sherall and related Siouan-speaking tribes. That's been the consistent theory. As a result of that theory, the Lumbee people became dissatisfied with the name that the state of North Carolina had imposed upon them in the various state laws that recognized the tribe, first Croatan, then Indians of Robeson County, and then Cherokees of Robeson County. And as a result of that pressure from the Lumbee tribe, in 1952, the state of North Carolina conducted a referendum among our members and said, which name do you choose to go by? And we overwhelmingly, almost unanimously, chose the name Lumbee, which, as I indicated earlier, we had used informally since at least the 1920s. That's important, too, though, because it shows a link between the current Lumbee tribe and the Sherall community. The Lumbee tribe resides around Lumber River. Lumber River was named that in 1809 by the state of North Carolina. Previously, it was known as Drowning Creek. And the first recorded map of the area in 1724 by John Herbert identifies the Sherall residing around Drowning Creek. We have been there ever since. It's the same community regardless of the name. And let me say in one final point that, again, the administrative process that our opponents so embrace specifically provides that if there is an entity, a collective entity that has existed for at least 50 years, which is plainly the case at Lumbee since 1885 in the school records and the federal census records that show it, that entity can be recognized, and I'm quoting here, notwithstanding any absence of or changes in name. It's not the name, it's the Indian people that you're recognizing.
Final question. Final question I will direct to you, Chief Hicks. The issue of costs has also been raised here at this hearing today, and you noted that estimates from CBO are a little bit all over the board, may not be entirely accurate here. Can you clarify for the committee what factors you think might be contributing to these differing cost estimates? And I agree with my colleague from Oklahoma that while cost should not influence a level of recognition of tribal status, it is something that I'm dual-hatted. I'm not only chairman of the authorizing committee, I'm also chairman of the appropriating committee, and so I can't help but want to try to understand some of the financial implications of this. So can you, if you're able, try to clarify a little bit about why we've got such a broad range of estimates that are out there?
Well, I think, as was brought up by both senators, around that question, we've had a third party take a look at the prior CBO score, and one of the things that was flawed in that score was typically CBO does a 5-year financial score. In that particular scenario, they only included 4 years for some reason. In addition to, we're fairly certain that, all of the federal agencies, whether it's IHS, whether it's BIA, BIE, amongst others, were not adequately included in that number, because if you go back to the prior 2 CBO scores, one of those was close to double in years prior to this prior CBO score. And I think it was around 21, 22, without having my notes. But again, we think there were flaws in that particular score. The estimates that we think over a 5-year period is probably in the range of $2 to $2.3 billion over a 5-year period, if all agencies are included.
Thank you. Senator Schatz.
Thanks to everybody for testifying. I just want to make one final point. I know we've kind of gone around and around on this, but I think I speak for every member of the Senate on this particular question. Like, you can think we should defer to the administration, but we don't have to. Article 1, Section 1 of the Constitution gives us this authority. Now, there is a statute that also delegates this authority to the administration, but it does not require that recognition go through an administrative process. You can think we are unwise for not kicking it to the administration, but you cannot say that we're not permitted to recognize a tribe. That is a constitutional obligation and authority of the Congress, but specifically the Senate Committee on Indian Affairs. So if you want to make the argument that we need to build a historical record and that you trust this agency within an agency more than you trust us, that's fine, that's fair. But this is still our authority, and we clearly intend to exercise it.
Madam Chair, can I respond to that?
Senator Cortez
As a member
Masto.
of the Senate. Yeah, I'm sorry, but I did not hear anybody saying that we don't have that authority. I think it was very clear that people recognize there's dual track here. And the question is, Lumbee has chosen one path, and they're asking us as members of Congress to support that path. And there's another side that's saying, no, there's an evidence-based path. That's what's before us. I did not hear from anybody, nor have I heard that somehow they're preventing us as members of Congress from doing our jobs. So I do, as a member, I don't want you speaking for me, I do recognize both sides of that.
Senator Cortez Masto, I don't think anybody said that directly today, but I will say that some of the organizations that have been steadfastly opposed to Lumbee recognition have actually made advertisements about circumventing the administrative process and undermining the tribal recognition process by going to Congress. And so that's what I was speaking to. I know it was sort of obliquely referred to, and you were suggesting that we were going to, that it would be better if we go through the administrative process. My own view is that this is a congressional authority, that the DOI has screwed this up for generation after generation, and that it's time for us to make a choice.
Well, I want to thank the members of the committee. I want to thank those who have come to testify today. I appreciate you helping us continue to build out this record. Members may submit additional questions for the record if they choose. The hearing record will be kept open for 2 more weeks. I also want to thank those who have attended. We're a pretty small committee on most days, and we don't have to go into a big committee room like this, but I think those who have joined today are evidence of the interest in this as an issue, and I think your presence is important to us as well. Know that this committee takes very seriously, as the Vice Chairman has said, our role and our responsibility when it comes to federal recognition of our tribes and ensuring that the sovereignty that they have is recognized by us in Congress, by the administration, and the responsibilities that we have. I want to thank everyone for the testimony that you have presented in a way that I think has been respectful, which is very important to this, the debate, the dialogue, the discussion, because I know that it can be contentious, and I know that oftentimes issues like these pit neighbor to neighbor, community against community, and that is hard, and particularly when you have been living with it for decades, if not over a century. So I respect the way that you have come to be before the Senate Committee on Indian Affairs today and your contributions. With that, the committee stands adjourned.